push the society, push the society to acknowledge us as equals in all respects, because the Constitution says so. And the moral authority of this court, it is not only legal authority, Milan. This court enjoys moral authority. It enjoys public confidence. Judgments of the court and the wisdom and the prestige of the court depends on public confidence. The public has confidence in the court. It's not a case where the public has no confidence, but they are bound to follow only because, my lord, there is a decree of the court. The decrees will be violated by people if people don't have confidence. So, my lord, we rely on the prestige and the moral authority of this court, apart from Article 141. That when the highest court of the land has said that there will be no 377, that you will have a right to marry, that there will be no discrimination in public places. It is that, with great respect, my lord, whether Parliament follows it up with the law or doesn't follow it up with the law, that is what will drive the society in times to come, 2 years or 5 years, whatever it be, to accept this group as a fully homogeneous group with their differences and diversities within one whole. As Justice Bhatt used the phrase, not one whole. That's how, my lord, that's what we are looking at.
They want us to settle.
My lord, my friend is right in saying, our parents have by and large accepted us. We are outside the closet. So we have gone through the process with our parents already, who belong to an earlier generation, to whom it was not the norm as we understand, because the closet was not opened 50 years ago. They have accepted. They want them to settle. They want them to have a family. They want them to have the same recognition, my lord. They don't want them to be ostracized. That the children are ostracized and the parents are ostracized. Oh, you have children who are not normal. So the ostracism will reach there also. It may reach their close friends. All that, my lord, has to be wiped out if the constitutional goal of the preamble, as reiterated by this court in Nalsa, Puttuswamy and Navtej, my lord, have to be given full effect.
These petitioners, their parents.
My lord, in my case, the first case, the ceremony was conducted by the parents, my lord, 10 years ago. So they also, my lord, went through some kind of transformation or whatever you may call it.
By more people.
Yes.
Yes.
And they had a reception in their
They had a reception.
in their hometown.
They had a reception. Some people, my lord, I have read, because you can't get married here, they go abroad and get married. Get a certificate from there. So there are all kinds of, my lord, situations.
Small town, 30
Yes, this was a small hometown. Yes.
30.
Then, my lord, now, my lord, something very important. Kindly turn, my lord, to para 553. There is, my lord, in Justice Chandrachud's opinion, a huge discussion of foreign cases, but para 553 is, my lord, US versus Windsor relating to DOMA, which I had given in that chart. So that description is here, my lord. It's important to read that.
Because Nepal, recently 2 weeks ago, another judge from Nepal has come with translation by tomorrow.
Only one more thing, my lord. Mr. Kirpal tells me just above 551, there is a reference to Nepal, my lord.
Yes.
There is a reference to Nepal just above para 551.
What is that? Sunil, some Sunil.
Yes.
Sunil Babu Pant.
Just above para 551.
550.
550.
Lord, we'll get this translation tomorrow. A judgment was.
This is a quote. Fine. After this, another.
After this, my lord, another thing has come yesterday
2 weeks ago.
or 2 weeks ago. We are going to translate it and, my lord, try and give it to you.
Nepal Supreme Court.
Yes, ma'am. Yes.
Which para? 5?
50.
I was reading, my lord, two lines above 551. In concluding, the court directed the Nepalese government to enact new legislation or amend existing legislation to ensure that persons of all sexual orientations and identities could enjoy equal rights. So now there is a fresh judgment reiterating this position, and we will translate and give it to lordships tomorrow or day after. So it's not a case of urban elitism. Say from Nepal, my lord, certainly not urban elite. Now say 553. In 2013, in the US versus Windsor, the US Supreme Court considered the constitutionality of Defense of Marriage Act DOMA, which states that for the purpose of federal law, the word marriage and spouse referred to legal unions between a man and a woman. Windsor, who had inherited the estate of her same-sex partner, was barred from claiming federal estate tax exemption for surviving spouse since their marriage was not recognized. Kennedy J., writing for the majority, held that restricting the federal interpretation of marriage and spouse to apply only to opposite sex unions was unconstitutional under the due process of the Fifth Amendment. In the DOMA, it's DOMA's unusual deviation from the tradition of recognizing and accepting state definitions of marriage operate to deprive same-sex couples of benefit and responsibility that come with federal recognition. This is exactly what I seek, my lord. I respectfully submit, my lord, it is exactly what I seek from your lordships, my lord. This is strong evidence of a law having purpose and effect of disapproval of a class recognized and protected by state. DOMA's about purpose and practical effect are to impose a disadvantage, a separate status, so a stigma upon all who enter into same-sex marriage made lawful by the unquestioned authority of the states. So the laws of the states of the US was at variance with DOMA. That you also find in my chart also. Then 554 below. Obergefell. 2 years later in Obergefell, while analyzing precedent of decisions US courts recognizing same-sex marriage, Kennedy J. observed, a first premise of the court's relevant precedent is that the right to personal choice regarding marriage is inherent in the concept of individual autonomy, like choices concerning contraception, family relationship, procreation, child rearing, all of which are protected by the Constitution. Decisions concerning marriage are among the most intimate that an individual can make. Kennedy J. expressed the need to go beyond the narrow holding in Lawrence, this is that Lawrence, Texas case, towards a more expansive view in Obergefell. Lawrence invalidated laws that made same-sex intimacy a criminal act. But while Lawrence confirmed a dimension of freedom that allows individuals to engage in intimate association without criminal act, it does not follow that freedom stops there. Outlaw to outcast may be a step forward, but does not achieve the full promise of liberty. This is exactly, my lord, history repeating itself here. Your lordships have, my lord, annulled 377 as it was annulled in the case of Lawrence. But it can't stop there. It has to go forward. It has to go forward, my lord, with a declaration that we are entitled to the same rights of marriage as anybody else, so that we can walk, my lord, in public spaces. Now, my lord, yes. Now, then, my lord, next passage is very important. By a 5-4 majority, the Supreme Court ruled that the fundamental right to marry is guaranteed to the same-sex couple by the due process and the equal protection clause of the 14th Amendment. Commenting on the right to marriage, Kennedy J. noted, "Not this definition is classic. No union is more profound than marriage, for it embodies the highest ideals of love, fidelity, devotion, sacrifice, and family. It would misunderstand these men and women to say they disrespect the idea of marriage. They are pleased that they do respect it so deeply that they seek to find its fulfillment for themselves. Their hope is not to be condemned to live in loneliness, excluded from one's civilization's oldest institutions, namely marriage, my lord. They ask for equal dignities in the eyes of the law. The Constitution grants them that right."
From your own marriage, that's for you. No relationship has been.
So, my lord, if this is good for society as a whole, it has to be good for us. It has to be good for us. And there is no reason that we should not be included in the whole We should not be included in the whole or the wholesome, my lord, group of society. My lord, now, my lord, the principles at para 561, that is, my lord, the crux. The principles, and then one or two more passages, and we are done with this. Kindly turn to para 561, my lord. 2 pages down. From an analysis of comparative jurisprudence from across the world, the following principles emerge. Sexual orientation is intrinsic element of liberty, dignity, privacy, individual autonomy, and equality. Intimacy between consenting adults is beyond the legitimate interest of the state. Then we got point 5. Point 4.
When to read all that?
Yeah, I'll read all of them. Yes, I'm grateful. 561.2. Intimacy between consenting adults of the same sex is beyond the legitimate interest of the state. Sodomy laws violate equality by targeting a section of the population for their sexual orientation. Such a law perpetrates stereotype, lends authority of the state to societal stereotypes, and has a chilling effect on the exercise of freedom. The right to love and to a partner to find fulfillment in a same-sex relation is essential to a society which believes in freedom under a constitutional order based on rights. Sexual orientation implicates negative and positive obligations on the state. Not only requires the state not to discriminate, but calls for the state to recognize rights which bring true fulfillment. This is the affirmative part, my lord. The earlier part was the negative part, or the negative injunction. The constitutional principles which have led to decriminalization must continuously engage in a rights discourse to ensure that the same-sex relationship find true fulfillment in every facet of life. I pause here for a minute. This is what I'm driving at. I require beyond the badge. I require this, my lord, I respectfully submit. Beyond the badge that I am married. Every facet of life where we face pitfalls when we go outside, my lord, the courtroom and deal with, my lord, like ordinary mortals. This is what we, my lord, face. The law cannot discriminate against same-sex relationship. It must also take positive steps. This is the affirmative part. The state should rather, my lord, come forward and say, all right, we accept gracefully, not grudgingly. The solicitor referred to the affidavit filed in Navtej. We were in Navtej. The affidavit said we leave it to the court. But the court commented on it in Navtej that we wish that you should have taken a stand in just leaving it on our shoulders. So it's not a matter of grace that the court said there, oh, we leave it to you. That's what the comment is in Navtej, Milad. Now, Milad, 564. This evolution has enabled societies governed by liberal constitutional values such as liberty, dignity, and privacy, equality, and individual autonomy to move beyond decriminalization of offenses involving consensual same-sex relations. Decriminalization is, of course, necessary to bury the ghost of morality, which flourished in a radically different age and time. I submit, my lord, history is repeating itself. This was only 5 years ago. But decriminalization is a first step. Please mark this, my lord. Kindly read, my lord, the conclusions with this. If this is the first step, the affirmative steps remain. And I submit, my lord, that the prayers that I respectfully seek from your lordships are affirmative steps which will help me lead a dignified life like any other person. Then, my lord, then your lordship may see only one more.
So the last 4 lines of the
Yes, my lord, I'll read.
Constitution principle, yeah.
Yes. Sorry, my lord, I should have read those.
51.7.
I should have read those.
564. 564.
What was they reading? After the first step, the constitutional principles on which it is based have application to a broader range of entitlements. The Indian constitution is based on the abiding faith in the constitutional values. In the march of civilizations across spectrum of compassionate global order, India cannot be left behind. We have to at least go hand in hand with Nepal. Let's forget anything else. We are in this region. Let's not talk about the America. In the US also, a large part of the society is very conservative. Large part. That's why, my lord, you had this DOMA and this, that. And the fact that now in the recent past, they have gone back, my lord, on abortions. They've gone back on abortions. It's not as if that, you know, they're being a industrialized country, they're very much ahead. The entire South, the rednecks as they call themselves, you know, they are conservative.
After Oberge fell, they have
So after Ober fell, it has been accepted
An act now.
and they passed an act now. I mentioned that.
opinion changes.
So things change when the moral authority of an institution says that this is how, please, you look through this prism of gender neutrality. Do not look through the prism. Milord, sorry to go back. This Victorian morality issue, Milord, came in 1800s when, Milord, Mr. Macaulay framed this law. You go back to Indian text for hundreds of years, Milord, you go to Khajuraho, go to other places. You see, Milord, these acts are depicted on the walls for thousands of years. That remained, Milord, the concept of morality. It was not, Milord, this Victorian morality which was in India for 1000 years. Our morality was very, very different, far more advanced, not Victorian, not stereotype, not stigmatized in this form, not, Milord, this formal thing. You can go to so many places and see. But when, Milord, it changed, we have had a succession from, Milord, Lodi dynasty. Lodi Gardens, Milord, dynasty, 1000 years old. Then came, Milord, the Mughal dynasty in the 1500s when Babur came. Then came the British. They occupied India. They imposed, Milord, their code and their moralities. So the society has traveled, Milord, through, I mean, Milord, twisting, if I may say so, twisting sands of time. What we were thousands of years ago, what we were, Milord, in the Mughal period, what we were, Milord, in the British period. And that British period stuck because they made the laws. They conquered India. India became one, Milord, dominion, like Africa, like many other dominions. We became a dominion, and those laws were imposed on us. Those Victorian morals were imposed. I am not on a debate, Milord, what is right, what is wrong. But that is how the shifting sands of time have, Milord, gone over thousands of years. That's why these words are important. That in the march, Milord, in this march, India can't be left behind. And more so, Milord, at least we don't have a debate like England. They don't have, Milord, a written constitution. So it's a matter of debate what the conventions are or what they are not. We have a written constitution like the US. Our constitution is very, very clear. And this, Milord, golden thread, if I may use again, Milord, the preamble 14, 15, 16, 19, and 21, is now cast in stone by several judgments of this court on secularism, pluralism, constitutional morality, no right, Milord, of the heterogeneous majority to steamroll the minority. And in the recent past, we start from Nalsa. I can go back, Milord, to a large number of judgments. But then that debate, Milord, will unnecessarily go on. We don't need that because there is no discordant note. Wherever there was a discordant note, Milord, your lordships have corrected. MP Sharma had a discordant note. And MP Sharma is of the 50s and 60s, Milord. Your lordships have corrected. My Lord the Chief Justice, Milord, also corrected. ADM Jabalpur. It's a discordant note. One discordant note, MP Sharma, another discordant note. They have been corrected by this court. So, Milord, this court has proceeded in the last 70 years, by and large, on one track, upholding the values of the Constitution, talking about constitutional morality, talking about the fact that if one man, Milord, is discriminated, he can come to the Supreme Court, notwithstanding that, Milord, hundreds and crores stand one way. One man has the right to come to this court and he need not wait for Parliament. Because this court is the guarantor, Milord, and the protector of fundamental rights. The lordships have said repeatedly. Repeatedly. I mean, you don't need to cite cases of that. So if that is below the position and India has to go forward, this court takes the lead with its moral authority and legal authority in providing a declaration saying that this is the next step after 377. Look, Mr. Society, this is the norm. Follow this norm. Remove the dogma. Remove the stigma. That is why, my lord, your lordship said, give wide publicity. That's not normally, your lordship don't say that normally. The reason is you are dealing, my lord, with something which is a little out of the normal. It's not, my lord, a case of property or, my lord, money going here or something. It's not one of those cases. It's a very different case. So the obligations, my lord, rest heavily on this court because of its moral authority and the public confidence in the court, more than, my lord, the legal part. Now, my lord, para 600 is very important. Kindly turn to para 600 and 601. And then, my lord, 2-3 more paras, then we are done with this. And the last para of Justice Indu Malhotra, which I will read, my lord, that we owe an apology, etc. But, my lord, para 600. Constitutional morality requires in a democracy the assurance of certain minimum rights which are essential for free existence to every member of society. The preamble to the Constitution recognizes these rights and liberty of thought, expression, belief, faith, and worship, and equality of status, of opportunity. Constitutional morality is the guarantee which seeks that all inequality is eliminated from social structure, and each individual is assured of the means for reference to the rights guaranteed. Constitutional morality leans towards making Indian democracy vibrant by infusing a system of brotherhood. That is, your lordships are now talking about fraternity. This brotherhood takes you back to the principle and phrase fraternity, my lord, in the preamble. Brotherhood comes from fraternity. There is no other phrase of brotherhood in the Constitution. Your lordship may only note fraternity comes, my lord. Fraternity and brotherhood is the meaning of one or the other and is relatable to the Constitution. Class, race, or brotherhood among a heterogeneous population belonging to different classes, races, religion, culture, caste, and section. Constitutional morality cannot, however, be nurtured unless as recognized by the preamble. So, my lord, emphasis on the preamble, which became a part, my lord, was declared as a part of the Constitution. There exists fraternity which assures and maintains the dignity of each individual. Then, my lord, Dr. Ambedkar's decision fraternity. Kindly turn to 601. And as I said, my lord, when the Hindu Code came in 1950, Parliament was not ready. The Hindu Code, my lord, was not only Hindu Marriage Act. It had adoption, success, so many things. So, my lord, it's not accepted. And Dr. Ambedkar had to resign. Then it came, my lord, in a truncated form. First, my lord, this Hindu Marriage Act, then Succession Act, and the adoption, guardianship, all that, my lord, came separately, not as a part of the Hindu Code bill. So the import is, what was not accepted in 1950 was accepted by Parliament in 56, 58, etc. when it went on. And then became the norm of society. Because nobody says today that there is some error in the Hindu Marriage Act. Prior to, my lord, the Hindu Marriage Act, one could marry, my lord, 3 times. A Hindu could marry, have 3 wives. That became, my lord, an anathema when India progressed to the Hindu Marriage Act. That was the law prevailing from the times of the Mughals, the British. So we brought in a new social order. Sorry.
This is the double-edged sword. Because then the argument of the other side is let the parliament do it. And
It's all right, but
Society changes.
point is, Milad. Sometimes, as I said, Milad, the law takes the lead. Sometimes society takes the lead.
Mr. Rotigi, your broad argument there would be that we are talking of constitutional morality. When
Myra.
somebody performs it, that is also constitutional.
That's right. I'm grateful. And Milad, the simple answer is this, to this query being raised again and again. The power, jurisdiction, obligation, and responsibility of this court, Milad, which is cast on this court, under the Constitution is only cast on this court. Even the High Court doesn't have that power. Only this court, as the final protector of fundamental rights and the final arbiter of what the law is and what the Constitution is. 32 is itself a fundamental right. If, my lord, I have a right, and that right is not being, my lord, given its full play, is being clouded or shrouded in some form by the majority, and if I may say so, by the state accepting the majority as correct, I have a right to come to this court, and this court will fail in its duty under the Constitution if, my lord, it does not remedy my right. Say, no, I can't do anything. You wait for Parliament. My lord, there can't be a mandamus to Parliament. I have no voice in Parliament. I have a voice to come to, my lord, open the doors of this court and come here and plead before your lordships. None of us have a right to go anywhere else. Except to, oh, you are a representative in Parliament, you go to your MLA, you tell your MLA, MLA will go there. That's not an answer, my lord, to the Constitution.
The constitutional touchstone only.
I am grateful. That's, my lord, where it stands. And, my lord, this argument has been raised in other cases also. Oh, only 10 or 20 people are affected. Thousands have accepted. Take, my lord, some resolution or some decision of a government. Your lordships have always, my lord, struck down the argument. If one man is affected, he has a right to say that he is affected. If his grievance is valid, then the court will act on it. And that this 100, 200 business was one of the foundations, my lord, in Kaushal. Your lordship may note that. That judgment, my lord, which overruled Nas of this court, which was overruled in Navtej and Puttaswamy, that judgment said, oh, you are a small minority, you are piffling minority,
Minuscule, man.
and 200 prosecutions, what's a big deal? In a country of 100 crore, this is minuscule. So, my lord, something like de minimis. Your lordships have a principle of de minimis. If it is so, my lord, inconsequential, the court may not act.
Yeah.
That judgment was founded, my lord, on de minimis. The point is, if one man's fundamental right, my lord, is affected, he has a right to come. And that judgment, therefore, was completely wrong in applying a principle of de minimis on the violation of a fundamental right. My lord, in Shafin Jahan, there is a passage, Lordship Justice Chandrachud, reminding the High Court that you cannot, my lord, go with just, my lord, this majority. I said, my lord, I'll show that.
Part of current.
No, all right. Let me read Ambedkar. Mr. Kirpal wants me to read. My lord,
Always good to read.
my lord, para 600 at the bottom of that page.
Yes.
600.
Man who faced discrimination
Yeah.
himself.
Yes, of course. My lord, your lordships are aware in London, wherever, my lord, famous people have lived, their names are, my lord, in a blue plaque on a building that here lived, say, X or Y. And one of those houses is where Dr. Ambedkar lived. With that blue plaque, they give the period where so and so lived, whether it's a Churchill or whoever it was. That's what Ambedkar. An ideal society should be mobile, should be full of channels for conveying a change taking place in one part to the other parts. In an ideal society, there should be many interests consciously communicated and shared. There should be varied and free points of contact with other modes of association. In other words, there must be social
Osmosis.
endomosis. What does that mean?
Endo-
Endo-osmosis. This is the fraternity, which is also another name for democracy. In his address, last address to the Constitutional Assembly, he defined the fraternity as a sense of common brotherhood of all Indians. As in the social and economic plane, Indian society was based on graded inequality. Dr. Ambedkar had warned in clear terms, without fraternity, liberty, and equality cannot become equality cannot not, and therefore is this that way, cannot become a natural course of things. It would require a constable to enforce them. Without fraternity, equality, and liberty, there'll be no deeper than coats of paint. Constitutional morality requires that all citizens need to have a closer look at and understand and imbibe the broad values of the Constitution, which are based on liberty, equality, freedom. Constitutional morality is thus the guiding spirit to achieve transformation, which above all the Constitution seeks to achieve. The acknowledgement carries the necessary implication. The process through which a society matures and imbibes constitutional morality is gradual